How you doing? How you been? What's going on? What's good? How you getting it in? Body getting it funny. What's going on, people?
Hey, what's up? It's officially almost 2 o'clock. Actually, it's after 2 o'clock in the morning. I want to talk to you about something in reference to a girl, trans woman, who's being sued by her mother. And now, this is in Minnesota and stuff, and I just wanted to do a little short because I don't want to do it long because the videos are really long. And the reason why I'm doing this is because I wanted to point out different things to you in reference to points that I found out through the story that she was saying, the mother was saying. And I want to show you different things as far as her story. And I want to show you the highlights and everything. But I want you to listen to this video, and I want you to listen to everything clearly. And I also want you to watch the mother's face as far as the, you know, the lawyer and everybody else as far as, you know, the storyline. And to my sister out there who, now they said the lawsuit took place when she was 15, then they speculated to 16, then all of a sudden it's 17, so the website is going all over the place. That's why, you know, our websites and stuff. But you know, there's a contradiction even within that, within the mother and stuff. It seems like she really don't know when the daughter actually was put out. But anyway, I just want you to watch this video because I pointed out a lot of highlights, and I want you to see this. And for my little sister in Minnesota, you know, your mother's giving you her way, I want you to stay strong. I want to let you know that you have a lot of sisters out here that's rooting for you. We got your back. So don't be thinking crazy, feel like you're all alone, because you're not alone. I'm going to let you know I love you, and I want you to keep fighting, and I want you to know you're not alone. I'm over here, and I got your story, and I'm letting you know from here to there that I love you. You keep fighting, because you in this together. Don't never think you're alone, because you're not. Anyway, I want y'all to watch this video, okay? Love you. A 17-year-old trans teenager is being sued by her mother for seeking to transition without her consent. The teen, who could not be named for legal reasons, does not live with her mother and does not contact her. She sought out the help of the government agencies to begin her process. On Wednesday, Anmarie claimed in court that her parental rights had been infringed, and as well as suing her daughter also suing the county health board, school district, and local healthcare nonprofit organizations. In a statement to report, she said, "It was brought to my knowledge that my son began receiving hormone replacement treatments from Park Nicole Health Service to transition from male to female with medical assistance paying for this. I was not consulted or informed in any way. Even though Minnesota law states any minor who is living separate and apart from their parents and who is managing personal financial affairs may give effective consent to personal medical and health services, and the consent of no other person is required."
And the understanding in the medical community is that this statute means that whether a teenager is emancipated when they present themselves for services, we're basically talking here about non-emergency services, that determination is made at the front desk. So basically, if the child can pay for the services, that means the doctors, the medical service providers treat them as emancipated. So here the sequence is, the teenager goes to the county with the letter from the legal aid clinic, and the legal aid clinic is taking the position the kid's emancipated. The teenager then gets the eligibility from the county to fund living independently. Then goes to the doctor and says, "Look, I'm eligible for these benefits and insurance," and then the medical services are provided. So this happens every day in Minnesota, and the concern here from Anmarie's perspective is that in these procedures where the county's involved, the medical service providers are involved, and I didn't mention the school district's also involved, also the Department of Motor Vehicles that are defending the case, they're kind of involved. All these things happen as if the child's emancipated when there's been no notice and opportunity heard for the parents. And so this is about having a day in court. And the reason why this law was challenged, I believe, back in 2003, 2004 by the House repealing these provisions, and then it didn't pass the Senate, is exactly this issue. And so this is not a new issue for Minnesota. It's been around. And whether there needs to be parental consent when teenagers want to get non-emergency medical services. And my client's position, at least with the severity here of this huge decision, changing from being a boy to a girl to the hormonal therapies and other medical procedures are required, she believed that she should have gotten notice and not to be heard, either before the services commenced or even after the services commenced. The fancy legal terms are, well, if you don't get a pre-deprivation hearing, pre-termination hearing, you should get a post-termination hearing. And when Anmarie talked to several attorneys before me, and they basically told her, there's nothing you can do. And so what I'm saying is, well, there's nothing that a lawyer can do in state court, so you have to go to federal court to find that her procedural rights are being violated because she can't go to state court and assert her parental rights. Are there further questions?
Yeah, are these legal services marketing to these kids? How are these kids finding out these legal services? I wouldn't think this would be a known thing that's happening.
Yeah, if you go to the judicial website and you look under health topics, then you find that the Minnesota Judicial Department is saying to teenagers that you can petition to be emancipated, and then you should contact this legal aid clinic. And then the teenagers go contact that legal aid clinic. Then what they do is they provide this emancipation letter based on the child's allegations. So you can imagine, this legal aid clinic interviews and then just produces a letter without talking to the parent. And then the state agencies, in this case, are relying on that letter for the emancipation. And so those lawyers are not due process for the parent. They're facilitating emancipation without court orders, and that's what we're opposed. We think that just like in the marital dissolution, paternity and child protection areas where the procedures are codified, that those procedures need to exist under the U.S. Constitution. So another way to put it is, the way that we know Minnesota cares about due process rights for parents prior to termination of parental rights is that Minnesota has codified, put in statute, the procedural due process for parents prior to termination of parental rights in those three subject areas of marital dissolution, paternity, and child protection. So, in answer to the question, and kind of going back to it, this happen a lot. But we're talking about emancipation. Is emancipation, are there as many emancipated teenagers as there are children involved in marital dissolution proceedings? No. But I would tell you that if in a marital dissolution proceeding, if we were terminating rights, honestly, terminating rights of parents without notifying the parents, you would all be horrified. I mean, you think about that. You have a marital dissolution proceeding, and there's a hearing about the child's welfare, and the parents aren't invited. Right, and that's what's happening here, is that Anmarie isn't invited to these administrative hearings or whatever processes you have at the county and in the school district, and also the statutory process that's being followed by the medical providers. She's not invited. She's not welcome. So it's all one-sided. Are there further questions?
Anmarie, I have to ask, why does your son want to be emancipated, or how long has he, I'm assuming, not been living with you?
Well, I would assume I asked him to wait until he was 18 to make any major decisions with his life. Just, hang on and just, let time play out here and just wait until you're 18 to go about, changing your name or your identity. And he was eager to have that done. That would be my honest answer.
And while you're there, I assume you have custody. It's not like there's a divorce and somebody else's custody. So nobody in the family was notified of any of this?
No.
Okay.
When will your child be 18? He will be 18 coming in July. So this all started when he was 15. And it's been a really long process because we went through 3 different attorneys before, I was directed towards Erick. And so it's been a very long process. We were hoping to have some things resolved long before with hopes to stop these elective medical treatments, at least until he finish puberty and that sort of thing.
Do you anticipate a decision on this before July?
I can't answer that honestly.
Yeah, Anmarie has other minor children as well. And so, yeah, we anticipate decision for July, and we don't anticipate the case to be going to move July either. Every parent rights are at stake with respect to Anmarie. She has additional minor children younger than JDK, so the case will be ready.
What kind of a process actually happened? Is there some sort of a hearing or anything, or did he just fill out a questionnaire and they said okay, or?
Yeah, that's a great question. There's so at the Mid-Minnesota Legal Aid Clinic, it's referenced in and I think actually in the complaint, if you have one, the Minnesota Legal Aid letter is Exhibit A, and so they went through some questions, and then they said, in our view, legally dubious, that he was emancipated. Then he went to the medical service provider, and the medical service providers were relying on the statute that I mentioned that says that medical service providers can provide, once the child's emancipated, provide medical services, and then went to the school district and did a similar thing. Now, the school district doesn't have a statute. They're just winging it, I guess. And so then that's kind of what happened, but Anmarie never got notice. What she got was, I'm not going to provide you any information. She would call and she would write, I'm not going to provide you any involvement in your son's decisions. And so it was done without any, court process or even administrative process. And so what our point basically is that, you go talk to lawyers when this happens in Minnesota, and they're actually right that they can't do anything for Anmarie. And so then here's the little asymmetry, and I know this is technical and legal, but it wasn't obvious to me when I started. It took a long time to get to this position. But the asymmetry is the background of the law is the common law, and so the common law recognizes that the teenager can bring a petition for emancipation, as shown on the Minnesota judicial website. But when you have a statute that says the medical service providers can emancipate for medical decisions without a provision for her to have notice and opportunity to be heard, the common law doesn't save you because the common law said that there's no right in common law for her to petition the court to de-emancipate a child. And so the statute must provide a provision for her, at least post-deprivation, after it's done, in a sense, to establish her parental rights again. And it doesn't mean that the parent wins. Again, in Minnesota, the courts have always taken this view, it's always about the best interest of the child, but that doesn't mean our parental rights too. And so that has to be balanced in the process. So that's why I mentioned in the Minnesota Supreme Court cases regarding emancipation can be partial, conditional, or temporary. And that's what we expect in a lot of these cases, particularly as a child approaches 18. And your question?
Yeah, so what happens when it goes, if it goes in Anmarie's favor? I mean, what happens then? Are you going to stop his transitioning? Are you going, what's the plan?
Yeah, it's a great question. Because we're moving on an as-applied basis, the remedies we seek only apply to Anmarie and the family. And so what would happen would be that the medical service providers, the school district, and the county would have to stop acting as if he's emancipated. In every situation, parental consent would be required until two things, right? One, Anmarie's provided an opportunity to litigate in state court the issues, or two, a JPK goes to court and gets a court order of emancipation. I want to go back to the question just quickly. One of the oddities here, why I kind of woke up to the claim and the process, and it wasn't a long process studying this, that was that JDK sought a name change in Stearns County and in St. Louis County. And so this kind of shows how contradictory right now the system is. So he was able to get the medical consent for these life-changing treatments, but then when it came to a name change in both those counties, the judges said, you don't have a court order of emancipation and you haven't given notice to your parents. And so they said, no, you can't change your name. So that's what the court's saying. And then the administrative agencies here, the school district and the county, and then also the medical service providers are saying you're emancipated. So there's a contradiction. Now, it doesn't mean that we can't live with contradictions, but here, because the parental rights are recognized as fundamental liberty interests under the 14th Amendment, we have to pay attention to procedural due process, and that's why the lawsuit makes a tremendous amount of sense. And even I want to talk about the medical expert I talked to, I think he was about 70, and he had been in the profession a long time, and he said, you know, the medical community is unified on this, Eric. Because I had to hire an expert before I filed this, because I couldn't believe this is the way it worked. And he said, this is the way it works. And he said, but as a parent, I understand you have a point. And so when we're here, and we all of us probably know medical service providers, and you ask them, you know, well, does it really work that way? They're going to tell you yes, and then they're going to agree, well, yeah, the parent has a point. There should be some process, at least after the emancipation decision's made, to be heard.
Yeah, so how is it different from a teenager going to get an STD check or going to a therapist and saying, I want you to not tell my parents, you know, what we talk about or my results or something like that, versus what we're doing now? Yeah,
there are situations like that that were addressed when this law was enacted in 1971, and then when it wasn't repealed in 2003, 2004. And those are some of the policy reasons given for not requiring consent. In fact, they even mentioned in the one of the reports I saw, the 2003 repealer, was that this idea of requiring consent for medical services would cost $11 million in the state of Minnesota. But the point is, you could say the same thing about eliminating parental due process in all child custody contexts. So the point being, you know, we are willing to pay to have due process for parents before their parental rights are terminated. So in that case, there might be an extra step required of getting a court order or parental consent before providing services. And yeah, it is an extra step, and it does cost money. But our view is parental rights are important. The sponsors of the law obviously thought they were less important than we do.
Is Minnesota unusual in its approach? How do we compare to other states?
The research that we've looked at is that other states do have emancipation statutes that do have the due process procedures, but I'll get back to you on that. I didn't do the research. No.
Just if you could clarify for me, exactly what are you asking for?
We're asking the court to enjoin the defendants from acting as if this teenage child is emancipated until there's a court order of emancipation or Anmarie provided a process in state court to resolve the emancipation issue. And so it's technical, but that comes with the territory and the procedural due process claims.
And so you said that, I can't remember who said it, but they were talking about hormones and they said that they're dangerous to this child. Well, there are tons of kids that are going through transitioning in the United States. Dangerous to who? I mean, to me it sounded a little objective because there's kids that are now using hormones. So when you say that they're dangerous, I mean, isn't that what the medical field is for, to properly give those hormones to children who are transitioning?
Yeah, I think that, I guess Anmarie can probably speak to that as to her view. I don't have to have a view on that. Every good.
Well, first of all, I can say that, nobody, even at 20 years old, would go back and make the same decisions as they would at 16. No, I mean, I can't imagine any of you in this room would go back and go, yeah, I was proud of that moment in my life. So, by dangerous, and I'm not the one who stated that, but I have an opinion on that, is that I've done a lot of research in this because I care so deeply for my son and I want to be involved in this process, is that I learned that for those kids transitioning, if he changes his mind in the future, and not that he will, and that's not what this is even about, but to answer your question is that if he did change his mind and he wanted to have a family of his own, some of the side effects of these hormone replacements are that he would become sterile and he would not be able to have a family of his own. And I guess, with the FDA, they do a lot of research on certain medications that are prescribed, but I think that was lacking in this sort of area of the medical field. And so he himself has described to me that the hormone replacement has caused him to feel suicidal, that it's caused him to feel very crazy at times. And the doctor reiterated to him, that's perfectly normal. You're like a little girl going through puberty is what they told him. And they also told him that the best time to do this is now before you are completed with puberty, which I disagree. I'm not saying he should be one way or the other. I'm not pushing that. I love him unconditionally, and I mean that unconditionally. I just wanted him to slow down and let himself develop naturally and see if he still felt the same way at 18 when he is a legal adult as he did at 15. And so that's the best that I can do.
How does he feel? How does he feel about this?
He knows about this. We've asked him to be a part of it, and his only fear was that he would lose his treatments. He understands it completely. He agrees, Mom, you should have had a day in court. He agrees with that. And he also agrees that he received bad legal advice, but he also says, well, it's working. So, I mean, a typical 16-year-old response, I think. So, the child will be 18. He will be 18 coming in July. So this all started when he was 15. The child will be 18. He will be 18 coming in July. So this all started when he was 15. I mean, a typical 16-year-old response, I think. So, yeah, I think that I think that he's experiencing confusion from all over, not just this one thing. I think that when we went through puberty, I think we were all a little bit kind of crazy and confused. But, yeah, that's where does he live? He's got his own apartment.
How long has he had his own apartment?
It's probably been, I'd have to look in my notes, 6 months, something like that. We helped him get furniture for it. I don't approve of him living on his own, but when I went to visit him, I'm kind of like, well, you need some stuff here, So we got him some furniture and some dishes and things like that. So I love him, and at his apartment, it was all white walls. There's nothing. I'm like, this kind of, except for the padded walls here, we really need to get you some life in this apartment. So we're working on doing that. I have family members who help get stuff for him just to help him.
And he's been out since he was 15, or out of the house since?
No, he was 15. Yes, he went to live with his dad. His dad and I are not together. We have two boys together, and because he's very intelligent. My son, JDK, is extremely intelligent. I would not deny that on any level. He excels very much in academics. And with what he was going through, he wanted to go to a different school. He wanted where there was more educational opportunities for him. And after some lengthy discussions and agreements, I agreed to let him go live with his dad. And in that process, this all sort of took place, and Dad moved, and he was kind of...
Did his father have any part in this, or in him becoming whatever kind of emancipated he is? Or?
He very much objects to this, and he's in agreement with me that we should at least have our side of it heard. I mean, I can't imagine taking anybody's one side of a story. We should always be seeking to find, I always say that there's her side and there's his side, and then somewhere in the middle is the truth, right? Because we're all persuaded by our own perception of what we believe and how we feel. And so he disagrees that we should have been heard.
Since you've been involved in this, have you talked to other parents in similar situations?
I'm not finding anybody in a similar situation, but I do talk to other parents who are very involved in the community. And with the transitioning thing put aside, because that's not even the issue. The issue is that he's able to just go make these decisions, and then, what stops anybody else's child from doing the same thing? Maybe somebody wants to go get emancipated. His mom says, you can't have a tattoo, but they want a tattoo. You know what I'm saying? And so they agree very strongly and are fearful that this could happen to them, regardless of what their child may be going through.
Representative, as a former school board member, which I've heard you say a few thousand times, have you seen examples of something like this happening in schools that they consider a student emancipated without a court order?
Yeah, repetition is the key to learning. That's why I repeat that so often. There's certain incidences. I don't want to go into specifics, but I haven't seen specifically an emancipation letter, but there is sometimes referrals for medical treatment without parental notification, and that is a concern. That was a concern of mine when I was on the school board, and it continues to be as a legislator. Again, I don't like to see the undermining of parental authority without any type of due process legal procedure. So, and that's, I guess, the root of the situation.
Have you seen, I guess, what I call an elective medical procedure, like whether it's this or something else, happen without an emancipation order, court order?
No, I haven't.
Okay. And Erick, I have another question for you. Has a similar case come up in federal court, since that's what you're looking at here? And if so, how did it turn out?
No, we haven't found this particular fact pattern. And I think the distinguishable facts are this is the major non-emergency elective surgery statute that doesn't require parental notice and consent, and the common law not providing the parent an opportunity to petition and get the rights back. I did want to mention that the Minnesota Legal Aid Clinic letter is Exhibit A. B is the St. Louis County court order, which was a response to an earlier question, which states that you can't change your name because you don't have a court order of emancipation. So again, the court's recognizing that notice and opportunity to be heard is required for the parents prior to emancipation. And then C is the letter from Park Nicollet Gender Services, which was presented by JDK in support of the petition in St. Louis County to change the name. So that's how we got it. And so that letter is from Dr. Julie Farias of Park Nicollet Minneapolis Gender Services, indicating that the treatments are being provided. So, and so I just wanted to mention that those exhibits are included. Are there any further questions?
And to be clear, besides the gender change, did I understand, I think you said that the county has authorized payment to help him live by himself?
That's right. The county determined that he was emancipated, meaning that he was eligible for the programs. So, for example, how the insurance works is if Anmarie had a chance, she would have said, well, he's covered under my insurance policy. The government should cover it. Then, of course, her consent would be required for the services. And so here, the county, by making JDK eligible for benefits like medical services, has enabled Fairview and Park Nicollet to provide these services that she objects to all without a court order. And so, you know, it's almost like, I was talking to Mr. Brackey about this, you know, it's almost like, okay, he goes to the county says, oh, you're independent, you get all this money, and then everyone else acts as if he's independent. But the county never provided notice and opportunity to be heard for the parent. And again, the result of an emancipation proceeding can be that you're emancipated conditionally, partially, temporarily. And so you can have the judge, you know, kind of make these distinctions, which are made every day in the context of child custody disputes.
Where's the medical expert from? Is he from Minnesota?
Yeah, he is from Minnesota.
Okay.
So, and are there any further questions?
Filed in St. Paul or Minneapolis?
And
U.S. North.
It's filed. We're filing electronically, and so the U.S. District Court, I guess the division would be the one, right?
Okay.
Yeah, but it's the one district of Minnesota and the different divisions.
So that's where any hearings likely would be?
Before the magistrate judge, that's an excellent point, that it's likely to be up there.
In regards to this lawsuit, has there been any precedents that would either hinder or help this particular lawsuit?
Well, I kind of did the less is more thing before, so I'm going to respond to this in a greater way. So, yeah, I mean, all the cases say that parental rights are fundamental rights under the U.S. Constitution, the liberty interest under the 14th Amendment. The 14th Amendment says that liberty can't be deprived without due process of law. So all the cases say that prior to termination of parental rights, a parent has a right to be notified and opportunity to be heard. Now here, because the non-emergency aspect of the medical services being provided, we can even say we don't get a hearing after the deprivation. So it's been announced that if by the medical service providers out there, he's emancipated, you can't get the information, you can't be involved, but there still isn't a process even after deprivation to go to state court. So yeah, all the case law runs in our favor, and the statute that we're talking about is constitutionally effective because it doesn't have a procedure for a parent to go to state court and fight back. Any other questions? Thank you for coming. I really appreciate it.
Thank you.